basically based in Mexico City, and then of course it is spread pretty fast across the country. Sorry, something happened with my and of course, many economic activities were like very affected by this spread of the disease. And our clients, mostly companies, we are our expertise is to assist companies in not just in employee matter but in other matters, and we have to make some strategies to mitigate those negative effects for them. So that's the background. Well, federal labor law actually has a technical legal procedure to mitigate those risks to avoid negative impacts on employers. So there is a basic rule. The government must issue a health contingency emergency, which means that is the suspension of any activity. That's the first step that has to be happen, and of course, then the employers will not have to pay full salary because the employers will not have to pay full salary because the employees are not working. So the law established that the employers will be obligated just to pay 1 month of salary, no matter the position, no matter how rank are the employees, just 1 month on minimum wages, which is an official measure to make some calculations, and that's it. That's the obligation to the employers until the new activities restart or commence again. So that's the main idea of our law, just to protect employers and employees, and of course, employees will have the right and support of Social Security institutions, Social Security rights, which is very interesting because it never stopped, and our hospitals were very crowded on those days, on that time. So that's the way the law protects the employers. That's something that never happened in Mexico. Actually, federal government never declared a health contingency. So they treated the pandemic as and let me say it correctly in English, is a health emergency due to force of majeure, which means it's not regulated by federal labor law. And of course, all the employers will not have the right just to pay that month of minimum wages. They will have to pay full salary to the employees, even if they don't work. That measure was taken by federal government as we believe for political reasons. It was a new administration in those days. It is we can call it like a populist government, but of course that was the main idea. And not just that, also the labor ministry, through the head of the labor ministry and the health ministry, just make public statements that all the employers will have the obligation to pay full salary during the pandemic to the workers, which means significant loss for companies in those days. And also they say that any dismissal based on pandemic reasons will be considered as illegal. So it was just very unfair to do. Of course, during the pandemic, many employers just realized that so many workers and so many companies could work through remote positions and remote arrangements. So basically, they go to home offices modalities, and of course, those employees which had the chance to fully work from home were entitled to receive the full salary payments, the full benefit package, of course, because they keep working, and that's right. The problem was the unionized employees, where they are going to be, because they can't perform their activities on a remote modality. They have to be on the facilities of the companies, they have to be on the work centers, and that was the problem, because with those statements, employees were and feel entitled to receive full payments and not work and not assist to work centers due to the pandemic reasons. Of course, they don't want to get the disease. But well, that's the basic reason, and something funny, because actually that's something that I'm going to talk ahead. Companies realize that, of course, home office works in Mexico. In Mexico, we have this background that the employee needs to be in their offices on the shifts, and the employer has to see it, and that's not going on. I mean, it's been amazing how things changed for the pandemic for us, because now we have this new type of work. So, what were the strategies that we developed to mitigate those effects in regard of the employees that are unionized? We just go to basic labor principles, which means we are going to have massive suspension of the employment contracts. That's something that we negotiate with all the unions across the country, and we assist to federal labor courts just to verify that those agreements are under good terms and in compliance with law. So the basic principle was, I'm going to suspend the employment contract for a bit of time, but in the negotiations, what happened is that employers just pay like 50% of the salary, 40% of the salary mostly, and we avoid with that dismissals. So the employees just get a certain amount of money to survive during the pandemic, and that's the basic principle. It is called technical shutdowns. It is not regulated by federal labor law, so it was a strategy that we have to develop just based on principles and basic labor principles. Another strategy that we use with those employees that can't work on remote modality but are not unionized, the absence of leave. It's the same principle as the technical shutdowns, but in an individual way. The employee and the employer just got like this agreement in which it's a suspension of the employment contract, and the employer pay in those cases like 50%, 60% of the salary. So that helps on the economy of it helps with the economy of the employee. So as a result, as I am saying, of these remote modalities that we never had in Mexico, it was pretty rare to have an employee that worked from home. We based a new model in Spanish model. It is called telework, and it's now regulated in federal labor law. It is not home office because telework have very specific provisions and very specific points that it will be considered as it. For example, the most important is that the employees must perform their activities for the employers outside of the establishments for 40% of the time, which means that you are under 40% of the time, you're not entitled to receive all the provisions that this modality provides. Just let me see, because it goes on, right? Sorry.
I think if you just reshare it.
Yeah. As I told you, it went out.
Are you out of Zoom
Yeah.
completely? Oh, you're gone. You're gone from. Okay.
Yeah. Sorry. No.
Yeah. Oh, we can.
Yeah. Oh, I'm just.
Do you have an HDMI port? Otherwise, we can connect it to the HDMI port. Yeah.
No. Yeah, it worked. Yeah. Well, as I'm telling you, this new modality just arises for pandemic reasons, for pandemic measures that we took, like based in home office, and we based our model in another models of telework that were operating for a time. For example, the Spanish is pretty the base of it, and this provision entered into force in January of 2021, and there have specific rules to follow. And I'm going to explain those the specifications in the next slide. Well, there are some provisions and some obligations for the employers through the telework modality. Of course, the employer will have to provide to the employee the correct tools to work from that modality. It means that laptops, cameras, cell phones, emails accounts, and the worker has to make a good use of it. So the employer in this case has all the obligation to provide any kind of accessory or item that the employee needs. Of course, there is very interesting, and in Mexico, we're in a pretty early stage. So in some cases, we don't know how to measure this cost because the law establishes that it is mandatory for the employer to pay internet of the employee and a part of the electricity that he or she used during the performance of their job. There is not an exact measure. So what happened is that we make some arrangements with the employee because I don't know, maybe there's a machine, but we don't know it to know how many watts they are using in daily basis. But well, as a matter of fact, we just agreed on common basis and avoid all these situations. Of course, the employee will be entitled to receive social security right as a regular basis. And of course, this is very interesting because the employer must provide an ergonomic chair to the employee just to follow health standards, which are pretty rare in Mexico. Well, we are in an early stage in this, so maybe it is common in other jurisdictions. But yeah, we have in some point like our clients like, do I have to buy this chair? Yeah, you have to, and you have to say take that receipt and show to the authority that you are in compliance with federal labor law. And of course, the employees will have the obligation to take good care of all these items that are provided to them. Well, as I was saying, the most important thing here at the first step of telework provisions are that the telework modality must be documented. It has to be documented in a contract, in an addendum, or any legal document, because without the document, you will not be in compliance with law and you can receive a fine. The telework must be voluntary. Of course, the employee has to be on goodwill and agrees with this kind of arrangement. Otherwise, there is not going to be legal. And of course, there is the possibility to reverse the modality to presence modality. Well, of course, there is these regulations. I don't know in other jurisdictions, but the privacy and the disconnection of the employee, it's very important to follow. Employers are allowed to use the cameras of the computers, and of course they have to respect the end of the shifts of every employee. So that's it from my side. Thank you very much. I don't know.
So there are some questions. Please feel free to ask Rogelio.
And did the support from the state?
Nope. No, never. Never. So we have to manage a lot of strategies like this and just to basic principles of law, because you know that this government is not is not that good with Japanese at that point. Now, yeah, because of course the pandemic concluded, and now we have these economic plans for foreign investors, but at that time, no.
Yeah, so you'll have to share your slides via the Zoom.
Yeah.
I think you are, aren't you?
Yeah. Is there a specific provision to hire people in the group?
Sorry.
Is there a special provision for living abroad?
No, there are not legal provisions. What is going to happen is that when an employee is outside of Mexico, the employee will not receive the social security rights of Mexican institute.
I have one question myself. It is interesting to see that the regulation in Mexico is very much a copy of the Spanish one. I was just wondering, what's the attitude towards teleworking in law firms? In our Madrid office, for example, we have a beautiful office and employees love to go there, but they got very used to not going to the office. And this happened for a few weeks, and in other jurisdictions, this happened for a few months. And it was really a problem to make them go back.
Yeah.
And it was really a problem for law firms to organize this new way of working. Just wondering how this
Well, it's funny because in our firm we have these new offices, and then the pandemic starts, so we have to wait 1 year or so to go back to the office. I didn't even knew my new office, but yeah, that's interesting. It is working very well. A lot of law firms are working through this modality because they have, habitual meetings through Teams or Zoom applications. And there is something interesting in Mexico that not just the common regular basis inside the law firms are accomplished, because we find out that we can work from home. But also in Mexico, there are new regulations about employment procedures when it comes to lawsuits. And now you can have those hearings on Zoom meetings or in a team meeting. So it is working really well in this early stage. Let's hope to keep it this way.
Other questions? We'll move on to Alex, who will introduce Dan for his presentation.
We're having some technical difficulties. I'll fill them for a few minutes.
Do you know any jokes?
Not that I can tell here. But no, I was really interested hearing the take from Maria and everything like that, because compared to these games, then what we have is just the States. Although we don't get chairs from our employers, so I'll pick it out in my own office when I get back.
Good luck.
Yeah. But no, it's been really interesting. I've been chatting with all of you over the last couple of days, just hearing the different approaches that governments are taking and companies are taking in different jurisdictions and things, just comparing it. So obviously, what we have in the UK, and especially as we move out to the further we have in the UK and then the other government support things that have been in place in other parts of the world, how that impacts on everyone going forward, I guess. But anyway, are we ready to go? Or should I
You have my personal message.
Your slides? Yeah.
Can we test, are you logging?
Not in Zoom, but we could plug in there.
If you have an HDMI,
Yeah,
you can connect to the.
There's always a couple ways to do that.
It's actually, but I don't know if it's a meeting.
I'm making sure
Yeah.
There we go. There you go. Okay. Should I? I'll say that one. I have one.
Okay, musical chairs.
Yeah. Okay. So no, yeah, this so I'll start sort of yabbering on because I'm just corporate lawyer, so I don't really know what I'm talking about here anyway. So Dan Schwartz, who is the chair of the litigation department at Solomon Ward Attorneys, and advises businesses and individuals on employment law, litigation, construction litigation as well, and business. I read from your website. So yeah, so I'll be quiet and I'll let Dan, who knows a lot about this, more than me, talk.
All right, thank you, and good morning, everybody. As most of you know, my name is Dan Gardner-Schwartz. I practice in San Diego, California, and this morning we're going to talk a little bit about how the employment laws were affected by COVID in the U.S. I'm always fascinated to hear how it's affected in other countries. And I'm sure that we'll be able to compare notes on that. And some of the things you said were actually very interesting in terms of a different way the U.S. approached things. One of the first things that I'll make an observation on is that unlike a lot of other countries, the U.S. does not have a very strong federalized system in terms of governing employees. There are certain minimums that every state has to follow, but otherwise it's really up to the states and the counties and the cities to layer on top of that various employment laws and rules and regulations. And certainly that's how it kind of evolved initially with COVID, but then the Fed stepped in and added a few fillers. So what I'd like to do with the few minutes we have this morning is just kind of explain some of the highlights of ways in which COVID affected employment law in the US, how it really dramatically changed the landscape in certain respects, and where the law had to kind of catch up a lot to the employers and the practitioners trying to help them in real time. And then maybe some future trends, which the only thing I'm certain of is most of my predictions will be wrong. But we'll, we can talk about that briefly. So in the beginning of the pandemic, I think the first reported case in California was like March 3rd of 2020. And what you had is you had the cities and the counties starting to issue emergency procedures, whether it's stay-at-home orders or other procedures that they required employers to ensure that their employees were being protected. This is before any state or any federal mandates came down. It was really kind of, like I said, a bottom-up type of response. I think the first order in San Diego County was March 12th of 2020. Then the state of California, what happened here? I'm going backwards. There we go. The state of California issued a shelter-in-place requirement in March 19th that affected every employer, and nobody could come to work starting March. Obviously, unprecedented situation, and I'm sure many people in this room were dealing with it, not just with their clients, but with their own staff and associates and everything else. We were all kind of dealing with this situation in real time, and the restrictions, these stay-at-home orders, included things with, obviously, like any good lawyer would draft, with exceptions. And one of the major exceptions were, well, stay at home for all non-essential services, which begged the question, what's an essential service? All my clients were asking me that question. So some were obvious, of course, healthcare workers were essential services. And even that is a very broad category, and I have a lot of clients that are on the edges. They're not in hospitals necessarily, but they're providing home care to elderly patients or whatever. And is that an essential service? So we had to go down that road. I have a client who is a contractor to the military, to the US government, to clean fuel tanks on aircraft carriers. Okay, they were an essential service. They're going on base, but we're writing these letters for our clients to provide to their employees that they have in their cars to show that they're an essential service provider. Not really because people are getting pulled over on the side of the road. There wasn't really a lot of enforcement mechanism, but as much as anything to give the employees the comfort level and the knowledge that they are required to go to work as an essential service provider, unlike a lot of their colleagues that are, sheltering in place. Where it got gray is where some of my clients were asking whether they could possibly fit into these essential service categories because they have, for example, I have a large furniture retailer that has shipping containers hitting the docks in the beach in LA, and they want to unload this product. They're desperate to unload it. They're going to pay massive storage costs. And can they possibly send workers down there to unload them and bring them into their retail stores for that limited purpose? So I'm trying to fit them into a category. And guess what? One of the essential services is providers that allow people to work from home. Okay. Well, everybody needs an ergonomic chair. Okay. So we said, well, look, to the extent that some of this stuff would be home office stuff, we can probably fit you into that. And we used that, and they got their stuff unloaded. But those are the challenges that we were facing during that period of time. Then the U.S. Congress starts to weigh in, and one of the first major pieces of legislation that President Trump at the time signed was this Families First Coronavirus Response Act. Now, what that did was, for really one of the first times ever, provide paid sick leave to people who had to be out of work for coronavirus-related reasons. Okay. Now, what that should tell you is one of the major differences between the U.S. law in general and other places is there was no federal paid sick leave. Okay, as a general rule, a lot of states had them. California certainly has a certain minimum requirement, but on the federal level, it never was. So they did this just for a coronavirus reason, and it was only really 80 hours of paid time off, but it was a major piece of legislation. It also provided unpaid protected leave of up to 12 weeks where you couldn't fire anybody if they had to be out for a coronavirus-related reason, including, for example, taking care of their kids because their kids couldn't go to school or whatever. So there were a lot of aspects of that law. Those are some of the highlights. It also allowed for flexibility in terms of giving employees unemployment benefits for a coronavirus reason, even if they didn't have to, they weren't fired or they didn't quit employment. If they had to be out for an extended period of time, they could apply for unemployment benefits to the state and get those benefits. So all those were major changes. But one of the real issues that we addressed right away is employers started to massively furlough employees. Now, that wasn't a termination because they still realized that they're going to need these employees. Nobody knew at the time how long this was going to last. But they knew that they had no business right now. So they furloughed them, which basically meant don't go to work right now, but you're not fired. And by the way, we're probably not paying you except to the extent we have to under state or federal law for 40 hours or whatever it is. So that raised a lot of legal issues, namely being, when is that really a termination? And at least in California, and a lot of the states would view this differently, but the California Labor Commissioner took the position that if you continued their benefits, you were still paying their benefits, and the furlough was for a specified period of time, typically no more than, say, 90 days or so, although there was never really a hard and fast rule on that, then that was not considered a termination. But if you said you're furloughed, but we have no idea when you're going to come back, in other words, employers were honest, okay, that would be considered a termination. And the reason why that matters is because if I'm deemed to have terminated someone, I have to pay out things like vacation or PTO pay, okay? And that was a huge deal for our clients who was literally furloughing everybody. This is not just one person that I might terminate and have to pay their vacation pay. It was all of them at a time when I had no income coming in, okay? Nobody wanted to incur that kind of liability. So these were very serious issues that people were grappling with at the time, and the law really was not substituting any kind of backup, at least in the early stages of the pandemic. So then the government steps in April, and they issue the Paycheck Protection Program. This was a massive, unprecedented program, almost $340 billion. That's billion with a B, dollars that was basically granted to almost every US employer. If you filled out a form and you submitted to the local banks and you showed what your payroll was, based on your payroll, essentially, you could get this loan from the US government. And if you proved that you used this loan for at least 75% of which went to your payroll to keep people employed, even though they weren't working for you necessarily, but you could use that for the payroll and then towards rent, so the landlords can still collect some rent, okay? That loan would be forgiven at the end of the year. It was free money. And it was a huge success in the sense that people were not terminated that would have been. There was also, as you can imagine, massive fraud, okay, involved with that. And not just kind of the typical fraud where people would inflate the payroll, okay? But fraud in the sense that people would apply for these loans because they really thought they would need them, they would get the money. And then guess what? The economy started to bounce back in June, July, and August. And they really could have, and in some cases did, use these employees also, okay? But they didn't adjust the loan amounts they got, okay? They almost double dipped in terms of getting the benefit of all this loan income without actually needing it, okay? But in the long run, I think it was ultimately a success in terms of it did save a lot of jobs and a lot of companies from going under during this very critical period of time. So, and I'm not going into every detail of everything that the states and federal government did, obviously. Now we come into May of 2020, and employers are actually finding themselves in a very difficult situation. They're trying to get workers back as actually things start to bounce back up, and they need people, and they're working on, telecommuting and home office and all this stuff. But whether it's working from home or coming into the office, they're having trouble getting people to come back at all. And there's a couple of reasons for that. First of all, people, of course, are reluctant to come in the office for obvious reasons. There's still a lot of uncertainty, as there still is, about the health and safety of coming in. But also, the federal government had been supplementing the state unemployment insurance providers. Typically, unemployment would provide about 50% maybe of someone's paycheck. But the government was giving the federal government was now adding between $300 and $600 to the average benefit that people would get on a monthly basis. And for certain low-income workers, they would end up making much more not working than coming back to the office because of those benefits they were receiving. And so employers couldn't get people to come back to work because why should I work if I can make more money not working? And that was a major problem that a lot of employers had during this period of time where they're trying to get people to work. And then, of course, we also had employers struggling to say, well, what rules should I follow? What safety measures should I take when I'm trying to get people to either telecommute? What are the rules with that? How do I track their time? And what do I have to pay for in terms of their cell phone usage and all? And we have the same issues in terms of how do we calculate that? We'll call it $5 a month. I don't know. Okay, but there were no real rules for that. And we started creating checklists for employers, firms like mine, and and this is on our website, you can see it, whatever. And we'd be pushing out almost weekly updates on our website about here's a new law and here's the changes and here's the rules. And here's the checklist you could consider when you're coming back. You should be gearing up on PPE. You should be gearing up on sanitation. You should be talking to people about what the notice requirements are. If you get sick, what should you be doing and how should it work? Okay, no regulations on this yet, but employers are dealing with this in real time in May of 2020. So then we come to kind of the end of the first year of the pandemic, and the laws start to catch up. States like California issue actual regulations that require employers to implement certain workplace restrictions for employees returning to work or otherwise. In California, you had to have what's called a COVID-19 prevention program. We had already been drafting these programs, then we had to redraft them to make sure they fit what the new regulations say. Some of the things they would cover would be obvious, But for example, they would make sure that employees can report exposures without fear of reprisal. And this became also a very tricky issue because there's a lot of privacy issues involved. If I'm ill for any reason, technically nobody gets to know that. Okay, that's my business. I just call in sick. But if I'm ill because I've had COVID and I was in the office, the employer needs to know so it can tell other people who are potentially exposed that they were potentially exposed. And they might want to not come in also. So there's a lot of issues we had to grapple with in terms of how to notify, when to notify, and the state began to step in and help us, but it was still not clear. So for example, in January of 2021, California updated its requirements to basically say that an employer had to notify employees within 1 day if they were around anyone else who had the coronavirus, okay, or had been exposed to the virus. So that in some sense gave employers cover to do what they'd already been doing, but it also made it, very expedited. You had to let them know within a certain period of time. The other thing that happened in the early part of 2021 is the vaccines started to become more readily available. Now, the states differed in terms of which categories of employers could get the vaccines earlier or not. Certainly, healthcare workers were at the front line of the vaccines. In some states, it was then teachers. In other states, it was not teachers. It was, people with over 65 or whatever. But we were helping employers navigate, the vaccines. But what became a much bigger issue into the spring of 2021 is whether employers could require employees to be vaccinated before they came into the office. Now, at this point in time, a lot of employers wanted their employees back in the office. They needed their employees back in the office, but they also wanted to make sure they had a safe working environment. And so they wanted to require vaccines. Now, unlike a lot of other countries, the US did not have a federal law that would let you have cover on that one way or the other. It was not just up to the states, it was up to the local counties or cities. The case law suggested that you could require it if you wanted to. And in some states, it was very clear that you could. In other states, in a lot of the southern states, for example, the legislation was issuing laws making it so that you could not require people to be vaccinated, okay? And, we get into a little bit of the culture wars now of what was going on in the US during this period of time. Employers are just trying to navigate, okay? They were trying to stay out of politics, but they can't avoid it if they're going to try and mandate a vaccine or not now, and these conflicting laws that are going on in the states. There's also, of course, societal and health benefits to try, mandating vaccines as much as we can. But there's a lot of information, arguments going back and forth. And there's also a cost, though, because if an employer decided it's the right thing to do, I'm going to mandate vaccines, but I have 2 or 3 secretarial assistants, let's say in my office, that say, well, that's fine, but if you mandate a vaccine, I'm out of here. I'm not coming back, okay? Now I have to go to my partners and have to say, I'm going to fire your secretary, okay, because she's not going to be vaccinated. That partner's not very happy with me. And by the way, all of us know probably, it was becoming a tight labor market into the latter part of 2021, where it wasn't so easy to find good help. So there was a lot of reasons why people were reluctant to require vaccines, despite some of the obvious health benefits. There was also obviously a cost to that. In California, at least, well, first of all, the federal government was requiring that if you let anybody go during this period of time, the what we call COBRA requirement was expanded. COBRA is the requirement where if someone leaves your employment, you have to cover their employee benefits, their health insurance benefits for a certain period of time. Okay, well, they expanded that during a period of time. So if anybody's leaving your employment, it's going to cost you more in COBRA benefits. Also, if I'm requiring vaccinations, I'm required to pay for the time that employee has to go to get vaccinated, okay? And if they're ill as a result of the vaccination, I have to pay for that time too, okay? That's at least in the state of California. So it's not necessarily a cheap proposition to require these vaccinations. So that, of course, we had fun navigating with as well. So we get into kind of some of the more current issues. In California, at least, we still have some safety obligations and notice requirements and all these return to work checklists and personal protective gear into January 2022. We still have other states challenging that. I mean, we had school districts in certain states that said, we want children to have to have masks. Okay, there's masking requirements, they have to mask. We're trying to protect the teachers because the teachers are getting sick and the teachers unions are up in arms and they're not coming to work, and we're doing that. And then we have the governors of those states pushing back and creating laws saying, no, you can't mandate masks. Okay, that's against our freedom of rights and all that kind of stuff. And I mean, this is still going on to this day, to some extent. Thankfully, I think the vaccine started to really take hold, and at least the severe consequences lessened so far. Coming into February 2022, a lot of the restrictions started to relax, and returning to work became much more prevalent. Okay, and a lot of people started to say, now you have to return to work. And we're still navigating with, okay, but if someone has a health issue or someone really doesn't want to, can we accommodate them and let them stay at home without upsetting all the people that would like to work at home, but we're requiring to work at come in because they haven't vaccinated or whatever. That's ongoing right now. And also what we saw is a lot of employers are making more definitive decisions now about who they're going to keep. Throughout the past couple of years, employers would furlough, they would start to bring people back, they would test it, but they also got a lot more efficient in some respects about how they're doing their business. And they realized, no, I don't need all these employees, or I can use some people part-time at home and not have them full-time in the office, okay? And so we're seeing a lot of employers now actually reorganizing and downsizing and of course, dealing with claims that inevitably result from terminating employees, but they're making more definitive decisions now about what their workplace is going to look like in the future. So, a few trends that may or may not turn out to be correct. Certainly, from the beginning of COVID to the present, I think one of the impacts has been what we call the K economy. Okay, where we had this big drop. Everybody experienced a big drop when COVID hit. And then a lot of us had a bounce. Most of us in the legal industry had a bounce. We've had great years, okay? But not everybody's been treated the same in the economy. There's been winners and losers for sure, and a lot of people are still on a downward trend, or at least a flat trend, and have not bounced up, typically in the lower income. And uneducated or less educated have fared worse. As employers streamline or become more efficient or automate or whatever else. I mean, everything's now handless and machine and all that. There are jobs that are being replaced because of that. So it's unclear to see if that now with inflation coming and other pressures on the economy, if they're going to come back up or they're going to stay down from on the bottom. Another impact that certainly has occurred in the U.S. is what some people call the Great Resignation. Okay, we've had very high levels of people voluntarily leaving the jobs they were in. Now, whether or not that has really impacted the economy is unclear. I read an article on the train ride from to Hamburg just a couple of days ago, the New York Times, that said, this Great Resignation is really a false figure, because even though a lot of people quit their jobs, they quit to go to other jobs. Maybe not necessarily in the hospitality industry because they're done with the hospitality industry. We all know restaurants are having trouble finding people, but it doesn't mean they're leaving the workforce. Okay, they're just going to other places in the economy. And there's also people that are leaving that are becoming what's called self-employed, the gig economy, so to speak, whether they're working for Uber or they figured out that they can live in Hamburg and work in the US and do online thing and whatever else. And they're not necessarily in the statistics that say they've returned to work, because that's not an official employment, but they're still out there engaged in productive activity. So it's unclear what the effect of this Great Resignation really will be. And then this is just a survey that was taken. I'm sorry, I can't read it at all there, given how light the coloring is. But I'll just kind of tell you what the survey. This was a return to work report from one of the major surveying companies. And it asked the question, what can companies do better as employees return to work? And the top one was perhaps not surprising. It was simply, well, I'd like more benefits. I'd like more 401k and more vacation, and I'd like more money. Okay. But then the other ones right behind that was office flexibility in terms of your work schedule, a hybrid office workspace. Okay. If we were already on a trend pre-COVID about, working from home and remote working, that pushed that right in through the door. And now we're all, whenever we interview someone, 20 to 35 years old, the first 3 questions they ask is, what's your remote work policy? So that's definitely here to stay. What was interesting about this survey for me was at the very bottom of the responses were a sense of purpose for my work. Okay. Now that was certainly not the case pre-COVID. Everybody was much more worried, all the ESG and I want to feel good and this millennial attitude. Okay. And certainly I think that's still out there, but I do think COVID readjusted their perspectives a little bit. Okay. It scared everybody a lot. And now they're really worried about, well, I want benefits and I want a flexible workspace. And I want to work from home. And if I have a sense of purpose, that's great. Okay. But a secure job is probably a little bit higher on my priority list. So that's just a little smattering of the wasp nest of issues that this has created for employers in the U.S. And I'm happy to answer any questions. Yes, please.
I hope I do not bother people with my question. A very technical question. You say that the country can say no, mask is not mandatory anymore, but the governor can change the decision. My question: who has the final decision? I suppose it's the governor and the county, but it's how does it work in the states?
Okay, that's a very good and very loaded question. Under the supremacy clause of the U.S. Constitution, ultimately the federal government can take precedence, essentially can preempt any laws of any lower jurisdiction in the state or county or whatever. Okay, but we do have this concept called federalism, where there are certain things that are strictly within the state's purview and not necessarily in the federal purview. But when it comes to things like health and safety or whatnot, if the federal government decided, if the US Congress decided to pass a law that said everybody in this country has to wear masks at work, okay, my guess is that would probably be enforceable and everybody would have to live by that, okay? Currently, there's no way that's going to happen. Congress is never going to pass that law, okay? And so you have some states that are more, I'll say, protective and concerned about the health and safety aspects. You have other states that think they're more concerned, I'll give them the benefit of the doubt, about the economy or freedom issues or what have you. And they're less protective in that respect. And that's why you have kind of all over the map right now in terms of what the enforcement levels are.
I have a question regarding the paycheck protection program. Have they been checked after they get the loans?
Yes, so in progress. The question was, have the loans that this federal government gave under the Paycheck Protection Act, have they been audited essentially or checked? Interestingly enough, when they rolled out the program, they said that any loans under a certain amount, I think it was like $1.5 million, are not going to be subject to an audit. I don't know why they said that, because so those are obviously the lower priorities, but there are audits that are being, and I think the message is really, if you're over a certain amount, you're definitely going to be audited. Okay, doesn't necessarily mean you won't be audited if you're under. But we also did something that was smart, that the loans were processed by banks. Okay, and the employees had to submit written documentation to the banks that was fairly detailed in terms of how much the payroll was and what amounts they would qualify for and all that. And so, you know, there's a paper trail if you are audited where you're going to get caught if, you know, you inflated your payroll by a significant amount or something. But what's interesting is there's a lot of ways. I mean, I had a client, for example, who was in the middle of a large class action lawsuit, a wage and hour lawsuit, okay, when this all went down. And he qualified for a very large loan from the US government. And we're in the process of settling this case. And the question was whether we could use some of that loan money towards the settlement, because arguably it was going towards unpaid wages that these employees were claiming, okay? Or whether or not we couldn't use that, because they're technically not necessarily what Congress probably intended. But, you know, but those were the kinds of issues that, you know, people were grappling with. They would also use this money and say, well, I'm probably going to fire a lot of these employees. They're on furlough right now, but I know I have to use this money or I'm going to have to get it back. Or, you know, the loan won't be forgiven. So I'm going to give bonuses to people that have really been working hard and really coming into the office and keeping my skeletal system afloat. I'm going to give them big bonuses and use the money that way. So if someone gets an unusually high paycheck, okay, more than they were, is that going to be subject to audit? Is that going to pass muster? We don't know. Rick?
The last slide that wasn't really legible, could you share that?
Yes,
I'd like to see that data.
I'd be happy to.
Not really an employment question, but extending COVID. What were the rules about gatherings of people?
So obviously it changes over time,
Yeah.
but during kind of the critical time there, at least in California, as I recall, they ultimately said gatherings of more than 10 people were not allowed, okay? And even if it was less than 10 people, there was social distancing requirements and things like that. So certainly, you know, firm happy hours with the associates were out, okay? Unless it was on Zoom.
Unless you're the governor
Unless you're the governor and you're eating in Milford or wherever it was.
and it's your birthday.
Yeah. Right. But, you know, look, you know, that was honored as much in the violations in the rule as some of the comments have reflected, but that was generally it. And then there was also these definitions of when you had to notify if one person got COVID, and then when you had to notify of what they called like a super spreader event or whatever, and the notification requirements were much more strict. Some cities would have tracing requirements, okay, like Los Angeles, you'd go in a restaurant and you'd have to log in and give them your contact information and all this kind of stuff, okay? And then San Diego, that didn't exist, okay, no tracing really. So it was really kind of all over the map, depending on what city you were in and how bad it was. And what that mayor or whoever decided to worship it.
So stemming from that, you mentioned, I think, in relation to the employment situation, the enforcement of those rules very lax. Does that apply as well in relation to gatherings?
Yeah, it was pretty lax. Certainly, I mean, you know, it's almost impossible to enforce. And there were some examples of, you know, them coming down. What would typically happen is if an employee got fired and became a whistleblower and said that employer wasn't following Cal OSHA rules on safety requirements, okay, and I told them that they weren't doing it and then they fired me, okay, which was their claim. Now the employer has to worry about whether they were following Cal OSHA rules. And that was always my explanation, trying to get everybody to comply with this stuff. I was, look, it doesn't matter if the state doesn't have resources to come in there, okay? If you get sued and you're not complying with this stuff, even if you fired them for all the best reasons in the world, they were stealing from you, whatever it is, you don't want to have to defend this case that says, well, we weren't complying with it, but. Okay, you want that's not the best defense.
Dan, I had a question as well. In Spain, we've seen a trend of employers having policies that allow their employees to work from anywhere in the world. This is beginning, but I'm very interested in knowing your take on that from an American perspective. If this is something that is going to be very, very common in the future?
I think you're right. I mean, and certainly there are some industries in the US where that's very much becoming a trend. For example, in the tech industry, okay, which is natural anyway, because, you know, they're used to working on computers. And part of that is the tech industry is based in Silicon Valley, and one of the huge problems that companies like Apple and Microsoft and Google all have is having people being able to afford to live there. Okay, I mean, they literally have their own buses to bus them from the suburbs into their campuses because it's too expensive to live in Palo Alto right now. So allowing them to work from anywhere is great for them. Okay, and that's fine. Now, obviously, it lends itself easier with some industries than others. And from an employer standpoint, the other problem that we have with that is, you know, you mentioned, yes, I think Mexico and probably a lot of countries, you still have to track people's time. You have to know how much they're working, when they're working, what equipment they're working on, is your trade secrets being protected? And all that becomes much more difficult when they're scattered into the wind. And so those, I think, are a lot of issues that are going to become kind of front and center as people decentralize their workplace.
So I make a comment about intellectual property. For example, in the United States, you're not allowed to export inventions. But when someone's legal partner is spending a month in Mexico, in his condo in Mexico, writing patent applications that he received from inventors in the United States, or trade secrets, for example. Ordinarily, everybody would be in the lab, but now everyone's on teams and trying to do things separately. How do you keep track of that? How do you enforce the trade secret when people are scattered everywhere? It's presented a lot of as yet unaddressed questions of law and intellectual property, and just in terms of how to maintain those secrets.
Yeah. I mean, along those same lines, even in terms of privilege, okay, and things like that. I was in Copenhagen before I came here, and when I first landed at the hotel, and of course I'm trying to do work because none of us go on vacation anymore. We just rearrange our schedules. So I'm trying to do work, and I can't get into my network. And I have a very strong Wi-Fi, and I can't get in, I finally email our IT person, and he gets back to me, he says, you need to link to your phone's hotspot. We won't let you link to that Wi-Fi network because that's an unsecured network. And he's right. I was like, oh, okay, I'm glad you're doing that, but you know, who knew? So we're doing, you have to be thinking through that because it's an unsecured network, but we're all in this Wi-Fi in this room, okay? Someone in that room can pick it off. And you know, that's going to be much more of an issue as employees are on the train and whatever they're doing with very sensitive information.
Actually, SMS is not secure at all, and we're now communicating with clients and other associates through just mere SMS. Now, iPhone's iMessage is encrypted end-to-end, but standard SMS is not secure, and therefore discoverable.
Yeah. Well, thank you, folks.
Before you run off, I think Fernando and Stefano have something to say. And then I think also Kendra, Gerhard, Barbara, Sven, we just have a couple of minutes. Sure. Yeah. I'm dragging from last night.
know me, just in case Stefan Ciccioriccio, Executive Vice Chairman of Asinet. Asinet is a network of audios and tax advisor. My colleague Daniel Ziska gave you some little information yesterday. I'm here I'm coming from, in spite of the tech, I'm coming from Rome, not from France, but